Frequently asked questions. Intent to hold for investment. One of the most commonly asked questions that we hear at Asset Preservation is this: how long do I have to hold a property before it's considered held for investment? What's that time period? And the answer to that question is actually a little bit more broad and nuanced than just the time period. The key issue in any 1031 exchange is that the taxpayer has an intent to hold for investment. Well, intent is very subjective, right? It's the taxpayer's intent, it's what's inside their head. What the IRS and tax court will look at are the objective factors that either tend to support and validate investment intent or contradict and tend to negate the intent to hold for investment. So keep in mind, the number one thing is the intent to hold for investment. Below that, you want to look at your unique facts and circumstances. And all of the facts and circumstances are taken into account. So certainly the holding period is important, but it's just one factor, and the IRS can look at all the factors. In fact, they will look at all the factors. In a perfect world, a taxpayer would have multiple factors that help establish the intent to hold for investment. And to the extent that there are factors that contradict that, it could lead the IRS to conclude the property was not held for investment purposes. So let me just do a quick recap. The most important aspect is the intent to hold for investment. Number two would be your unique facts and circumstances. And then below that, and this is important, would be what sort of objective factors, what sort of documentation, what sort of provable points do you have that help bolster or support that intent to hold for investment. So it's really important that 1031 exchange investors create that documentation and create that paper trail if they're ever audited down the road, that they can help us substantiate the property was held for investment purposes. Well, I started off talking about time, and there is no holding period anywhere under the Section 1031 code, no safe holding period. The intent is much more important. However, many investors still want to get an idea of the time period and have a feel for that. So I'll give you some parameters, but just keep in mind the more overriding principle would be the intent of the taxpayer and all of their facts and circumstances that help support that. But with that being said, some tax and legal advisors feel that 2 or more years is a fairly conservative holding period, providing nothing contradicts that. Others might look at a year or more. So those are a couple of broad parameters, but keep in mind there's nothing set in stone, and taxpayers have been below that threshold of a year and have still been able to demonstrate that they have the intent to hold for investment. A good rule of thumb would be the more months, the better. The fewer months, the more risky and aggressive. So the more months the taxpayer has of rental income and treating it as a property held for investment, the more conservative it becomes. The fewer months, the more risky and aggressive it becomes. There are a couple tax court decisions that help shed some light on these issues. In Goolsbee versus Commissioner in 2010, the taxpayer was denied Section 1031 tax deferral. And we'll look at this in just a moment. In Reesink versus Commissioner in 2012, the taxpayer only held a replacement property for 8 months, and yet it qualified for a 1031 exchange. Again, the time period is not the most significant factor. What was significant with that case was that they were able to demonstrate that their intent was to hold for investment. So let's quickly look at the Goolsbee case. In Goolsbee, they did not receive 1031 exchange tax deferral. So the taxpayer moved into a replacement property only 2 months after the exchange was over. They happened to sell their primary residence at the same point in time, and they exchanged into a replacement property that had restrictions under the Homeowners Association that prohibited renting. So right off the bat, a prudent investor is not going to exchange into a property that is restricted from being able to be rented. They didn't attempt to rent the replacement property at all, and then shortly after they acquired it, they made a lot of improvements and finished the basement to their own personal needs. And then finally, you'll see there that a non-privileged conversation with the qualified intermediary was taken into account. They told their intermediary that they never intended to rent the property. They never intended to hold it for investment. They intended to live in it and to move into it. So this is fairly obvious that all of the facts and circumstances pointed to it being held for something other than investment purposes. Therefore, 1031 treatment is denied. Now let's contrast this with the Reesink versus the Commissioner in 2012. This one did qualify for 1031 tax deferral. And the IRS and tax court, when they examined this, they found that there were a lot of facts and circumstances that supported the intent to hold for investment. So the taxpayers exchanged out of a property in the San Francisco Bay Area and into a replacement property in Northern California. When they did this, they placed many rental flyers throughout town showing the house is available for rent. They put a sign out in front of the house that is available for rent. They even showed the property to two potential renters. Now, neither one of them rented it, but they were able to demonstrate two potential tenants walk through the property. They had zero personal use in the property. And what happened was 6 months after the exchange was over, they ended up having to sell their primary residence. And the reason was the taxpayer was a husband and wife. One of the people lost their job and they were no longer able to afford the payments on their primary residence. So what they did is they sold their primary residence, and 8 months after the exchange was over, they moved into the replacement property in Northern California. The last bullet point says other supporting facts, and I'll just kind of give you a little bit more color on this. They had a son that was a freshman in high school, and they had told their friends and family and neighbors that they absolutely intended to move into this property in Northern California, but only after their son was out of high school. So he's a freshman in high school. What does that help demonstrate? They had a minimum 4-year period of time that they intended to rent the property. So I'm trying to share this with you to give you some examples that the intent is important. It really comes down to your unique facts and circumstances. And the more facts and circumstances that you have that are objective and that are provable, that help support the intent to hold for investment, the more likely you'd prevail in the event of an audit and someone looked at that. The fewer that you have, or those that contradict investment intent, the more likely that you'll be denied 1031 tax deferral. To review your specific 1031 exchange situation, contact Asset Preservation's headquarters in California at 800-282-1031 or our Eastern Regional Office in New York at 866-394-1031. Please read the full disclaimer, as Asset Preservation cannot provide tax or legal advice.